Good day, everyone. Today I will discuss Article 1624 of the Civil Code. An assignment of creditors and other incorporeal rights shall be perfected in accordance with the provision of Articles 1475, which talks about the assignment of credits and other incorporeal rights. What is an assignment of credit? Assignment of credit is a contract where the owner of a credit, called the assignor, transfers the right to another person called the assignee. This transfer can be done either for free or with payment. Now, when we say credit, we're not just talking about money owed. We are referring to incorporeal rights. These are intangible rights like the right to collect debt, lease rights, intellectual property rights, and so on. Once the credit is assigned, the assignee steps into the shoes of the original creditor and has the same rights to collect from the debtor. So, for example, let's say Anna lends 100,000 to Ben, payable in 6 months. 2 months later, Anna needs cash urgently. So she sells the right to collect the 100,000 to Carla for 90,000. Anna is the assignor, Carla is the assignee. Ben is the debtor. Now Ben must pay Carla the 100,000 when it becomes due, not Anna anymore, because the right was transferred. So legal basis, Article 1624 says that assignment of credits is perfected based on Article 1475, which is the rule for the perfection of sales. This means the moment both parties agree on the credit to be assigned and the price, the assignment is perfected even if no actual document or delivery has been made yet. However, ownership is only transferred upon delivery, as stated under Article 1498 and 1501. Let's move on Article 1625. What does this mean? And Article 1625 provides that an assignment of a credit, right, or action shall produce no effect as against third persons, unless it appears in a public instrument or the instrument is recorded in the registry of property in case the assignment involves real property. So, what does this mean? Between the assignor and the assignee, the assignment is valid even if done privately. For example, through a handwritten or notarized contract. But when it comes to third persons, the assignment only becomes legally binding if either it is in a public instrument, like a notarized deed of assignment, or if it involves real property, it must be recorded in the registry of property. So, if the assignment is not notarized or recorded, third parties, such as other creditors, buyers, or interested property parties, cannot be bound by it, even it's valid between the parties involved. So, example scenario, let's say Alice lend 500,000 to Ben. Alice later assigns that credit to Carla. They sign a private document only. Ben doesn't know about this. Then, Alice, acting dishonestly, assigns the same credit again to Dan. This time, through a notarized deed. Now, the question is, who has the stronger claim, Carla or Dan? The answer is Dan. Dan has the stronger claim against third persons, including Ben, because his assignment appears in a public instrument, making it enforceable against others. Even if Carla's assignment was earlier, it has no effect against third persons unless it was in a public document or registered property.
So now let's discuss the Article 1626. So Article 1626 is about the notice of an assignment. So this article states that if the debtor pays their original creditor before before being notified that the creditor has transferred or assigned their right to receive the payment to someone else, which is the assignee, then the debtor is released from their obligation. So in this context, the crucial factor is the lack of knowledge. For a payment to be valid, the debtor must not be aware of the assignment at that time they make the payment. So now let's go here. The law also stated that consent of the debtor is consent of the debtor to the assignment is not required for it to have legal effects because the duty to pay does not depend on debtor's consent. Um, if consent were necessary, creditors would face obstacle in assigning their rights, as they could be prevented by the potential refusal of debtors to agree to the assignment. So that is one of the primary differences that you would notice between subrogation and assignment. In subrogation, you need a consent from the debtor, and in assignment, you don't. So in the next bullet says about the effect of payment by debtor after assignment of the credit. Assignment of credit means the assignor or the creditor transferred the right to the assignee, which means now the debtor must make payments to the assignee. However, the debtor must be notified about the identity of the assignee to whom they should deliver or um, perform their obligation. So again, just like what I said earlier, if the debtor pays before the notice or they haven't been notified, then that's valid. Their payment is valid and that extinguishes their obligation. Since they are unaware about the agreement of the original creditor and its assignee, the debtor don't have an idea and will only pay whom he contracted to pay. So just like that. So again, to add, in such case, the assignee has a right of action against the assignor, the original creditor. So here's an example for you. So Mary owes David 1,000 and David assigned his right to receive the 1,000 to John. Mary, who is unaware of this assignment, pays David the 1,000 because Mary paid David before being notified of the assignment to John. Mary is released from her obligation and is considered to have fulfilled her obligation by paying David. So John's claim is now against David and not Mary. If John wants the money, he must go to David since Mary's payment to David is valid. Okay, so what happens if the debtor made the payment to the original creditor after the notice or they're already aware about the assignment? Now, that is considered not valid, meaning once the debtor is aware of the assignment, they must pay the assignee. If they don't and just pay the original creditor, that is not counted to extinguish their obligation, and that would show that they are acting in bad faith. And they risk themselves to having to pay twice. So again, if the debtor knows about the assignment and still pays the original creditor, they are not protected by this article and may have to pay again to the assignee. So this is an example. You could read it na lang. So again, before notice, valid payment and extinguishes obligation. Basta before notice. So after notice naman or before notice but already have the knowledge or is aware na sa assignment and pay the assigner, that's not valid. Because they must make the payment to the assignee. So go to the next one. So the next one, 1627, it provides The assignment of credit includes all the accessory rights such as the guarantee, mortgage, pledge, or preference. Since assignment of credit is transferring of rights, they are not just transferring the debit itself, they are also transferring all related rights that come with it. For example, if the debt is secured by a mortgage, the mortgage is also included in the assignment. This follows the familiar rule um, that is the accessory follows the principal, meaning any accessory rights that are attached to the principal or to the main credit go along with it when the credit is assigned. But the parties involved may also stipulate that the accessory right shall not be included in the assignment. You can specify which rights are transferred and which are not. And that will be all for Articles 1626 and 1627.
Article 1628, the vendor in good faith shall be responsible for the existence and legality of the credit at the time of the sale, unless it should have been sold as doubtful, but not for the solvency of the debtor, unless it has been so expressly stipulated, or unless the insolvency was prior to the sale and of common knowledge. Even in these cases, he shall only be liable for the price received and for the expenses specified in number 1 of Article 1616. The vendor in bad faith shall always be answerable for the payment of all expenses and for damages. If a seller or assigner of a credit acts in good faith, they are only responsible for making sure the credit exists and is legal or valid at the time of the sale. But the seller is not responsible if the person who owes the debt or the debtor turns out to be insolvent or unable to pay, unless it was clearly agreed or stipulated, or the debtor insolvency was already known to everyone before the sale. Liabilities of the assigner of credit. If the assigner is in good faith, the assigner is only liable for the existence and legality of the credit at the time it was assigned, and refunding the price received if the credit turns out to be invalid. Lastly, paying the assignment expenses and other legitimate charges related to the transfer as stated in Article 1616. Note that the assigner is not liable for the debtor's inability to pay or insolvency unless it was expressly agreed or stipulated, or the insolvency was known before the sale and common to public knowledge. Second, if the assigner is in bad faith, the assigner is fully liable, which includes the refunding of the price of the credit and paying all expenses related to the assignment, and also paying damages or compensation for losses. So, to know if an assigner is in bad faith, he knew that the credit didn't exist at all and was illegal, and the debtor also was insolvent but still sold the credit. Article 1629, in case the assigner in good faith should have made himself responsible for the solvency of the debtor, and the contracting parties should not have agreed upon the duration of the liability, it shall last for 1 year only from the time of the assignment if the period had already been expired, and if the credit should be payable within a term or period which has not yet been expired, the liability shall cease 1 year after the maturity. So, under this article, it deals with the responsibilities of an assigner when they guarantee the solvency of a debtor. If the assigner guarantees the debtor's ability to pay, they are responsible for their liability. If there is a specific duration agreed upon, this duration will be applied. If no specific duration is mentioned, The assigner's responsibility lasts for 1 year from the assignment if the payment period has expired. It also lasts for 1 year after the due date if the payment is still ongoing. Take note that these rules apply only if the assigner acted in good faith. If they acted in bad faith, different provisions will be applied to it. So, for example, the OC 50,000 due on July 1, 2025. C assigned this credit to E guaranteeing D solvency. So, the outcome of this scenario, if they agree C's liability lasts for 2 years until July 1, 2027, that's the set of duration. If they don't specify a duration and the assignment occur on August 1, 2025, then C liability lasts only until August 1, 2026. And if the assignment is made on July 1, 2025, C's liability ends exactly 1 year after July 1, 2025, which is July 1, 2026.
Uh, Article 1630. One who sells an inheritance without enumerating the things of which it is composed shall only be answerable for his character as an heir. Article 1630 says that if someone sells you an inheritance, meaning the rights to whatever someone left behind when they died, without listing without listing exactly what's included, the seller is only promising one thing, that they are legally an heir. If it later turns out that the seller is not really an heir, then the buyer can cancel or sue because the seller falsely claimed to be an heir. But if the seller is indeed an heir, then the seller has fulfilled their promise. Even if the inheritance turns out to have fewer or different items than the buyer expected. So example for this is saying, imagine Ash tells Bob, I will sell you my inheritance from my late aunt's estate. And she does not say what's in the inheritance. So according to Article 1630, Ash is only promising she is actually an heir of her aunt. If Ash turns out not to be an heir, example, if the will of her aunt is not her name, then Bob can demand the money back or sue Ash for falsely claiming to be an heir. But if Ash is indeed an heir, Bob cannot later complain that some of the inheritance items are missing or smaller than he thought. Ash never guaranteed the specific items, only her heirships. Article 1631. One who sells for a lump sum the whole of certain rights, rents, or products shall comply by answering for the legitimacy of the whole in general. But he shall not be obliged to warrant each of the various parts of which it may be composed, except if in the case of eviction from the whole or the part of the greater value. Now, Article 1631 applies when someone sells you a whole bundle of rights or product. For example, let's say all the rent income from a property or the entire output or harvest from a farm for one total fixed price. The seller is only guaranteeing the bundle as a whole is legitimate. That means they promise there is a valid right or product being sold. And however, the seller does not guarantee each part of that bundle individually. They are not responsible if a small part has a problem or is is missing. The only exception is if the buyer actually loses the entire bundle or the biggest pieces or the biggest piece of it because of a legitimate third party claim. This is called naman na eviction by the law. In that case, the seller must make good on that loss. So let's give an example to understand it better. Let's say Carl sells Diane all the corn crop from his farm this year for a fixed price or for a one total price. So under Article 1631, Carl is only guarantees that the entire corn crop is legitimately his and can be sold to Diane. He does not guarantee each individual ear of corn or each field's output. Then, suppose a small part of the crop is accidentally spoiled by a storm. Diane cannot blame Carl for that small loss. But if let's say, if a neighbor claims that the entire farm belonged to them and not to Carl, the, and Diane loses the right to harvest all of the corn crop or the largest field of corn, then Carl must make good on that loss because Diane was evicted from the whole bundle or the major part of it.
Article 1632. Should the vendor have profited by some of the fruits or receive anything from the inheritance sold, he shall pay the vendee thereof, if the contrary has not been stipulated. For example, Maria sells her farm to 1. After the sale, Maria harvests crops that were already growing before the sale. Since she profited from the farm after selling it, she must pay 1 for the value of those crops, unless their contract states that she can keep them. Next is Article 1633. The vendor shall, on his part, reimburse the vendor for all that the latter may have paid for the debts of and charges on the estate, and satisfy the credits that he may have against the same, unless there is an agreement to the contrary. For example, one sells his inherited land to Maria. Before the sale, one paid 50,000 pesos in real property taxes and settled a 100,000 pesos mortgage on the land. Since these payments are necessary to clear the estate, Maria must reimburse one for these expenses, unless their contract states that one will cover them himself.
Article 1634, when a credit or other incorporeal right in litigation is sold, the debtor shall have a right to extinguish it by reimbursing the assignee for the price the latter paid thereof, the judicial costs incurred by him, and the interest on the price from the day on which the same was paid. A credit or other incorporeal right shall be considered in litigation from the time he complained concerning the same is answered. The debtor may exercise his right within 30 days from the date the assignee demands payment from him. This article serves as a protection to debtors in cases that a debt is being contested in court, especially if it is sold to a third party. For example, Lian owes a debt to Rika. However, that debt is actually being litigated in court, and if Rika sells this debt to Mika while the litigation is ongoing, Lian has the right to clear the debt through paying Mika the amount that Mika paid for it, plus the judicial cost and interest. In short, this article allows the debtor a chance to justify clear the debt in case the creditor transfer ownership while in litigation. Article 1635 from the provisions of the preceding article shall be accepted the assignments or sales made. Number 1, to a co-heir or co-owner of the right assigned. Number 2, to a creditor in payment for his credit. And number 3, to the possessor of a tenement or piece of land which is subject to the right in litigation assigned. This article specifies specific cases by which an exception of the rule. For example, John and Jim own a house, but that property has a debt dispute. Now, if John buys the debt from the creditor, the Article 1634 will not be applied. So, what will happen here is that John will not be able to get the benefit of paying only what she paid for the debt. That concludes Chapter 8, Assignment for Credit and Other Incorporeal Rights. Thank you so much.